Business owners often want to know how long the process will take to sell the company. It can normally be completed in about 6 to 12 months, but there are some things that can be done to speed up the process that the seller can take control of. I think a couple of those that are very important is one is to make a decision that that's exactly what you want to do, is to get the company sold. Then you need to clean house. Make sure that the company looks good, that the books are in order, and that the due diligence materials that a buyer will need to take a look at are prepared. Working with a qualified intermediary can also speed the process up dramatically, because a good firm can build a customized marketing plan and specialized marketing materials that can tell the company's story quickly and in a compelling way to the greatest number of prospective buyers as fast as possible. Some of the issues that management should consider when they're thinking about selling the company are, first of all, what is the availability of shareholders post-closing in regard to transition and employment issues? What are the owner's objectives in regard to the sale? Are there some concerns about non-competition that need to be addressed in the transaction? But as an overall consideration, probably the most important thing is to think about how all of the concerns and issues of everyone involved in the transaction can be best taken care of, because there are a lot of stakeholders besides just the owners of the company. They're the customers, the vendors, the landlords, the employees, the creditors of the company, the buyer, of course, who has to succeed post-closing. So there's a whole group of people that really need to be taken care of by design as part of the transaction process. We're often asked if there are situations in which an entrepreneur should attempt to sell their own company. I think there are a couple of situations in which that might be the case. One is if you have your own in-house mergers and acquisitions firm, or possibly if you have that expertise on the board. Another situation is if the company is so troubled and the transaction is not going to generate much in the way of revenues, it may be necessary to do it. Otherwise, I'd say that you always do better with a qualified intermediary representing you. Entrepreneurs who try to sell their own company often run into these problems. Usually, it takes their eye off running the company, which is the most critical thing that they need to be doing in the process of selling, because buyers are really interested in the current run rate of the company and its current progress. So the entrepreneur's focus should be on growing and building the company all the way through the closing. Anything that detracts from the profitability and growth and operation of the company during the transaction process has the potential to really negatively impact the transaction. In general, what I find when entrepreneurs try to sell their own company is that the probability of closing drops dramatically. When they do get the transaction closed, it's been my observation that it takes longer, there's a lot more hassle, is a lot more costly in terms of legal and accounting fees, and almost always a lot of money is left on the table. We're often asked what is necessary in order to prepare a company for sale in terms of the marketing materials and packaging. And I think the key to that is to look at the M&A process as a custom sale, with the company as the product. So a specialized custom marketing plan is necessary that identifies prospective buyers and also addresses the selling proposition that might be made to each one of those buyers, because it can vary from buyer to buyer. The marketing materials have to be developed specially, and often they're customized based on who the potential buyer is. Sellers often have some trepidation about the due diligence process and ask how best to prepare. My suggestion is that you start as early as possible and that you work off an organized checklist provided by your M&A specialist or by your attorney and CPA, and that you begin to pull and prepare the documents that a buyer is likely to ask for as early as possible. Get those organized into a binder or into a set of file boxes and set them aside for when the due diligence process will commence. That material needs to be reviewed by your intermediary, by your CPA and attorney prior to release to the buyer. There are a number of potential gotchas in the contract process that can be avoided if you control the release of materials and if everyone involved knows exactly what materials are being released at what time. If you don't do that, it can come back to haunt you in a big way in the representations and warranty sections and in the indemnification sections of the contract. So it's important to prepare, but then it's also important to release according to the direction of the team as you move through the process. I usually don't release the material, or at least the material in general, until we've had a chance to review the due diligence requests of the buyer. There's no sense in releasing things that aren't requested, particularly if they're not materially significant to the disclosure process. And so it's really a nice idea to just hold back and wait until the buyer makes their due diligence request and then respond to that accordingly in an organized fashion. Preparing the offering memorandum for a company, or the prospectus, is an interesting process. It's important to portray the company in a positive light and to present an interesting and attractive future. It's also important to speak about the negative aspects of the company and its shortcomings. Sometimes sellers are reluctant to do that, but often those become the most salient selling points because buyers are interested in how they can grow and improve the company, and sometimes the shortcomings of the company are the greatest reasons that buyers get interested because they see how they can fix the problem. We're often asked how we identify prospective buyers for a company. It actually starts with understanding the strategy for the growth of the company through discussions with the owner. Sometimes it becomes very obvious who the buyers ought to be in order to be able to implement the strategy. Other times, however, it takes extensive research both on the web and through databases that we have access to in order to identify potential buyers, both ones that appear obvious and those that maybe aren't so obvious that might have an interest in the company. When we start the marketing process, owners frequently ask us, how in the world are you going to get in touch with potential buyers? Seems like it's almost impossible to get a hold of anyone anymore between email filters and voicemail screens. How in the world do you do it? Well, actually, voicemail and email can be very, very effective, and it's easier these days than it ever has been before. The key, though, is the message that you leave. You can't just call up a guy and say, "Hi, George, you don't know me, but we have a company for sale. Please call back." A better way to do it is to say, "George, I understand that your XYZ division is interested in expanding into the semiconductor test market. We represent a company who has a number of customers in that space, and it might be interesting to explore how your division and our client might be able to create some great synergies. Would you give me a call back, and let's discuss that, please." When we start the marketing process, owners frequently ask us, how in the world are you going to get in touch with potential buyers? Seems like it's almost impossible to get a hold of anyone anymore between email filters and voicemail screens. How in the world do you do it? Well, actually, voicemail and email can be very, very effective, and it's easier these days than it ever has been before. The key, though, is the message that you leave. You can't just call up a guy and say, "Hi, George, you don't know me, but we have a company for sale. Please call back." A better way to do it is to say, "George, I understand that your XYZ division is interested in expanding into the semiconductor test market. We represent a company who has a number of customers in that space, and it might be interesting to explore how your division and our client might be able to create some great synergies. Would you give me a call back, and let's discuss that, please." The manner in which you present your company to prospective buyers is important. First of all, they need to be pre-screened and qualified. Then they need to sign a non-disclosure agreement. Then it's important to keep control of the disclosure process and to disclose in stages as the transaction progresses so that you keep good control of your confidential information and control the process. Another important aspect of this is that when you begin to bring buyers to your company, it's important that it look good. Image actually is important, and the quality of your products, services, and the quality of your company is going to be judged by the quality of how it appears. As you might imagine, I have some pretty strong feelings about who should take the lead in negotiations of the sale of a company. And as an intermediary, I believe that should be the intermediary. Obviously, you need legal and accounting advice on specific matters, but as far as negotiating the business points of the transaction, I believe that the owners of the company, represented by the intermediary, are best able to do that and to put together a complete transaction in the letter of intent stage that fully describes the deal as both buyer and seller understand it. In the final contract negotiations, it needs to be taken on a case-by-case basis, and it often changes throughout the course of the final closing process who's in the lead. Often in regard to the contractual points, of course, the attorneys are involved in that and negotiate directly. In general, though, I think the intermediary should still coordinate and take control of the closing process and work closely with the owners to make sure that that happens smoothly, but serve sort of again as the point person and as the quarterback for the process, working with the seller, the CPA, attorney, and other advisors to the transaction. Here's a little negotiating tip when dealing with an experienced buyer. It's not uncommon for seasoned buyers to want to defer key business points, key decision points in the transaction until farther downstream and into due diligence. The basic strategy involved here is that the longer the deal goes on, normally the better it gets for the buyer. So it's incumbent on the seller and the seller's team to move the transaction along as quickly as possible and to define as many of the important business and deal points as possible in the letter of intent prior to signing an exclusivity clause. I think that what this does is it keeps the playing field level and makes sure that everyone understands what the deal is going to be before you move into an exclusivity provision. Because once you move into an exclusive dealing provision in the letter of intent, the balance of power shifts somewhat to the buyer. And while that's fine and understandable, it shouldn't happen sooner than necessary. Although most people talk about price when they speak about the sale of a company, it's actually much more complex than that. Price is obviously important, but the structure of the transaction is just as important. In fact, often there are many considerations that are as important as price in the whole transaction. For example, what's the currency being paid? Is it cash, stock, promissory notes? What's the likelihood that you're going to get paid? What's the term of payment? What kind of obligations will there be post-closing in terms of consulting, in terms of non-competition? What's the quality of the buyer, and how will the chemistry be between the buyer, seller, vendors, customers, all the other people? Sometimes the people offering the best price aren't necessarily the best buyers. So the whole deal needs to be considered in its entirety and evaluated on a case-by-case basis. It's not just about the price. There are many ways that transactions can be structured. It starts with who the seller is. If the seller is the corporation, assuming that you're structured as a corporation, then if the seller is the corporation, you'll be speaking about a sale of assets, selected liabilities of the company. Most frequently, buyers wish to buy assets because it minimizes their liability and enhances the deductibility of the purchase. On the other hand, if you're a C corporation, then selling assets is probably not going to be very beneficial to you simply because of the double tax impact of selling the assets. In general, not to move too deeply into the tax problems, but fundamentally, if the corporation sells its assets, it'll be taxed at the corporate level, and then when the proceeds post-tax are distributed to the shareholders, there'll be another tax. That can result in a very ugly outcome. So selling the assets of a company that's a C corporation can be very problematic. Unfortunately, selling the stock of a company, in that case the sellers would be actually the shareholders, and they'd be selling the stock of the company, is not necessarily that attractive to many buyers. They assume then potential risk from the operation of the corporation prior to closing, and the tax advantages to the seller are offset by some very significant tax disadvantages to the buyer. Therefore, you're often caught in a situation, and this is particularly the case with C corporations, where the buyer wants to buy assets and the seller wants to sell stock. This can often result in just an impasse where a transaction can't be accomplished because the net after-tax results of a transaction for buyer and seller simply can't be reconciled. So deciding what your corporate structure is and how to set up the sale can become very, very critical to a successful outcome. Okay, here's a good question. When do you discuss price with a buyer? This varies dramatically on a case-by-case basis, depending on the situation that the company's in. In some cases, it's important to actually build a marketing case and the sales message around the price and terms and deal structure that you're seeking. Often this is the case when you're basing the price of the company on future performance, and you really need to ground your claims that that's what will happen, and also orient the buyer that this is what your expectations are. Otherwise, you can end up going down a path with a buyer that can be quite laborious, and then find out that your expectations for price and what the buyer is willing to pay are so far divergent that it's impossible, and all you've done is just wasted a lot of time. Another time that you might want to discuss price and terms is if there are some special requirements that are actually conditions to sale. It could be that you have to hit a certain price in order to be able to sell, and there are some critical reasons to disclose that. It could be that you need to sell stock. It could be that you need to have a cash sale. If those situations really are conditions to the sale, it's not a bad idea sometimes to go ahead and get those out front. You might run off a number of buyers, but at least the buyers that show up will understand the rules of the game, and you'll have a much higher likelihood of completing a transaction under terms that you know that you can do. Aside from situations like those, however, in general it's best to let the buyer make an offer first rather than to going to market with a price. Again, price is important, but the structure of the transaction is just important. So often when buyers ask us about a company that we're taking to market, what's the price? I respond, not to be coy, I really don't know, because it all depends on how you'd like to buy the company. What's the structure of the transaction? How are you planning on paying? What are the terms going to be? How much of a hassle are you going to be to sell to? How's the chemistry here? Do we even want to sell to you? We're not sure. We need to know what the whole story is before we talk about price. It only can exist in the context of the whole deal. So in general, my suggestion is don't go to market with a stated price and allow the market to respond with the price and terms that they propose. That also works easier as a company changes, because sometimes things go up, things go down, profits go up, profits go down, new customers arrive, customers leave, and if you've gone to market with a price, then you have to go back and explain to people that might have looked at the offering memorandum earlier what's going on and try to renegotiate one way or another. So I think it's just simpler in the offering memorandum to leave the price and terms open to negotiation. One of the most important aspects of optimizing a deal is to create a competitive dynamic. Sometimes that can be done by an entrepreneur independently, but it works best with an intermediary, because it's important to get more than one buyer involved in the conversation. Or at least it's important to have the illusion or the threat of having more than one buyer in the conversation. What that does is it causes each buyer to do the best they can do. Every buyer will only do what they'll do, but our job as an intermediary is to get them to do as much as they'll do. And the way to do that is through creating a competitive dynamic that creates, in effect, a gentleman's bidding war and creates a situation in which there's pressure on the transaction that causes buyers to move quicker and to do the best that they'll do. It's not uncommon for a transaction to reach a stalemate or to get stuck. Where that usually happens is it happens somewhere in the development of the purchase agreement and the supporting documents, because there's a phenomenon that can happen there that I call fax wars, or in this day and age, email wars more likely, where there's a blizzard of documents flying back and forth, and the transaction seems to be hung up on a myriad of little sort of nitpicky points. People get frustrated and they begin to take positions that aren't necessarily conducive to closing the transaction, and it gets stuck. So how do you break that impasse? Well, my suggestion is at that point that you need to go back to the beginning, which is the relationship that was established between the buyer and seller. You need to move the CPAs and attorneys off to the side, out of the room. Buyer and seller need to get together face to face and let the intermediary actually mediate. Go back to the beginning. What are we trying to accomplish here, and how can we do that? And how can we clean up all of this, the misunderstandings and all of the nitnoid problems and issues that are going on around the contracts, and come back to the fundamental principle that we have a deal, we have business points that have been decided, and we want to complete the transaction. It's amazing how much can get done in maybe a half-hour or an hour meeting when you put the principals face-to-face. Now, often the attorneys and CPAs want to argue not to do that, but my experience has been that if If you get the principals face to face and they want to complete the transaction, they'll figure out how to do it. What's the most important document in a transaction? Well, it's clearly the letter of intent. There really are three documents that are important in a transaction. Sometimes you see a term sheet, which is a general expression of interest on the part of a buyer. That's not a bad document to have, but it really doesn't mean a whole lot. Then you have the letter of intent. We'll come back and talk about that in a minute. And then you have the purchase agreement. The purchase agreement is the binding definitive document in the transaction, and that's what's used and necessary to close. The letter of intent is actually where the deal is made, however. It's the most important document in the transaction, and you should use the letter of intent to either make or break your deal. The letter of intent often is viewed by many attorneys and often by buyers as simply, once it's signed, an opportunity to lock up negotiations and an excuse to negotiate some more. My feeling is that the letter of intent is where you make the deal, and that you don't lock up the company and enter into exclusive negotiations until you've thoroughly established every business point that's important in the transaction. And that's what you can do in the letter of intent. Most of the letter of intent is a non-binding document, although there may be elements that are binding. But fundamentally what it is an agreement between the business people of the transaction as to what the deal is. How's this going to work? If there are areas that are left open, they're just potential time bombs downstream. So my advice, strong advice to both buyers and sellers in regard to the letter of intent, is that if there's an open issue, resolve it before you sign the letter of intent. In fact, that's usually our instruction to buyers and sellers. When the letter of intent's ready to be signed, we'll pull the sellers aside and say, is there anything else that you really would like to address here or that you're concerned about the transaction? Because if there is, let's address it now in the letter of intent stage. Same thing with buyers. Are there areas that are of concern or issues that need to be resolved that we ought to talk about before we sign the letter of intent? If there are, let's do those before we sign. Because once the letter of intent is signed, if you've done this job properly, you're almost there, and the likelihood of closing is extremely high because the business people are really in accord as to what the transaction is going to look like. One of the issues that a seller needs to address early on in the process is to understand who all the people are that get to vote on the transaction and the approval process that will be necessary in order to actually complete the sale. So it's important to understand the shareholder structure, the board of director structure, also the other people that might have a stake in the business or a stake in the transaction. Often it's a pretty good idea just to make a list of all the people who are going to have an opinion about this sale and who might be able to block it. That could be shareholders, it could be boards of directors, it could be employees, it could be option holders, it could be landlords, it could be creditors, other vendors. In other words, the list can be quite long, and anticipating the issues on the seller's side as to who will need to be satisfied about the transaction can be critical to actually completing. It's also important to understand the decision-making process that the buyer will go through, and to make sure that you're negotiating with the people who can actually make the decision, or that if the people you're working with on the transaction are not the ultimate decision makers, that all along the way those people who will make the decision are informed, in the loop, and going along with the transaction so there aren't any nasty surprises at the end, both that could catch the people you're negotiating with by surprise and certainly catch you by surprise when the board of directors says, what, we're not going to buy this company, and scuttle the deal. Sellers of companies are often surprised at the number of documents and the complexity of documents associated with the sale of the company. There are two documents that are the initial documents in a transaction, the term sheet, which you may or may not see, certainly a comprehensive and detailed letter of intent, and then the purchase agreement, which is the definitive agreement of the transaction. However, there are other documents that go along with the transaction that you'll need to have negotiated and developed depending on the complexity of the deal. There can be employment agreements, consulting agreements, non-competition agreements. If seller financing is involved, there will be a promissory note, There may be guarantees, certainly security agreements, stock pledges. If there's bank financing involved that may be superior to the seller financing, then there are subordination agreements. Sometimes the owners of the company or the shareholders of the company are actually the landlords and own the real estate. Therefore, you might have lease agreements, option agreements, real estate purchase agreements, a whole variety of documents that can be associated with the sale of the company, along with all the approval documents and supporting agreements such as shareholder approval, board of directors approval. So it's quite a comprehensive list. That's why it's important to have a good transactional attorney that's associated with this process, because understanding all the documents and how they link together becomes really critical as the amount of paper begins to mount up. What are buyers looking for in the due diligence process? First of all, they're looking to verify the representations that the seller has made about the past of the company. Secondly, they're looking to assess their risk and the potential liabilities associated with the purchase. Thirdly, they're interested in determining what the current situation really is. And finally, they're interested in assessing the future and predicting what the likely results of the company are going to be, both in the short term and let's say out for 2 to 3 years. So the due diligence process involves all of that, and if the seller understands that and prepares for that in advance, then the process can go quite smoothly. One of the questions that we're asked often by sellers is, hey, I've got this skeleton in the closet, or this sort of negative thing that's happened. Should I tell the buyer? The answer is yes. You need to disclose fully, and you need to disclose early, so that there's no breakdowns in the negotiating process or breach of trust as you go forward. Since you have to disclose anyway, you might as well get it out early on the table and deal with the potential consequences of that. You should involve your CPA and you should involve your attorney, and certainly have this be done as a team approach as you go forward. What do we see as the future of the mergers and acquisitions process? Will it change? Will it get more streamlined in the future? Well, it's already gotten a lot more streamlined, and I think that that will continue. And the biggest tool associated with that, or the biggest development in that regard, is certainly the Internet. The Internet has helped to streamline the research process, the information delivery process. Certainly the contractual process has speeded up, sometimes almost too fast, because documents fly around almost to the extent that it's difficult to keep track of them sometimes. But the pace of transactions has certainly been speeded up by the Internet, and I think that will continue to happen. In general, though, I think the transaction process, the negotiation process between buyer and seller, and the decision-making process will probably not be much different in the future, 5, 10 years from now, as it is today. Because that's an innately human process, where a buyer has to make the decision and get satisfied, and seller has to make the decision and get satisfied to actually complete the transaction. That's certainly not something that's going to get automated. It might get speeded up more by the use of technology, but the fundamental human decision-making process isn't likely to change much.